Very good afternoon to all the students present for this session on compensation and reward management. Friends, we have discussed in this particular session, we have discussed the equity principles in details. We have discussed internal equity and external equity principles, and also we have discussed how this fairness principle is achieved through the processes of job evaluation, understanding the different factors that are comprising the job, and then assigning different monetary values. Then internal equity and external equity, you have understood how these pay surveys or these wage surveys can help us out in achieving this external equity. Similarly, we have also discussed the principle of fairness, that people should be paid in terms of their performances. So performance-based reward systems is what that we have already discussed. Today for this session, we are going to discuss the various institutions which do have the responsibility of fixing up these wages and salaries in our country. So continuing with that, the institutional mechanism, but we need to understand one thing, that whatever we do talk of in compensation and reward management, those rules, regulations, enactments has to be abided by the various rules, regulations imposed by the appropriate governments from time to time. So these public policies, the legislative frameworks, they do provide the base of the wage and salary determination. They do provide the base of fixing up and revising the wages and salaries. However, if we need to understand it in detail, we need to understand that all of these wages and salaries are determined in India in basically 5 different ways. The first one is that wages can be defined, or the salaries can be defined unilaterally only by the employer as a single party through the process of collective bargaining, where these bipartite negotiations do take place between these employers and the employees. They do fix up the various wage legislations, right? And this may happen at the level of the industry or at the level of the plant itself. We can think of this pay commissions as appointed by the appropriate government, right? From time to time, they do have the responsibility of fixing up and revising this wages and salaries for central government and respective state government employees. We do have wage boards also. Of course, nowadays these wage boards have lost their relevance, but wage boards are there, referring to particular industries where these wages and salaries can also be revised by these wage boards. Beyond that, we do have our legislative systems, or the administrative systems itself, which do take care of all of those aspects of wages and salaries, all of those grievances related to these wages and salaries, disputes related to these wages and salaries, settled through the adjudication process. Adjudication is like all these matters are to be settled, are to be finalized, right? Are to be decided by the respective courts. Like we do have labor courts, industrial tribunals, and national tribunals, three parallel layer of courts where any of these matters related to these wages and salaries can be settled. Of course, all of these courts need to have their own jurisdiction, and they need to finalize all of these wages and salaries as per the Schedule 2 and 3 of the Factories Act, which case can be referred to which kind of court, all of those, right? So let us understand. But one thing we need to take into account is that whenever we are talking of these wages and salaries, right? So each and every enactment that we do have in India actually are driven from the directive principles of the state policies, which is from Article 36 to Article 51 of this Part 4 of our Constitution. Of course, most of the directive principles are based on the recommendations of the ILO. India, as one of its original member of ILO since 1919, and particularly when after this Declaration of Philadelphia, when ILO was restructured in the year 1944-45. So since then, through its amendments, ratifications, ILO has brought many changes in the legislations related to these wages and salaries or the labor conditions itself. So here, what we need to understand is how these legislations are affected through the or are influenced by this directive principles of the state policy. Like one of the basic principle that we need to discuss is this Article 36, which says that which directs the states that they shall strive to minimize inequity in income and endeavor to eliminate inequity in status, facilities, and opportunities. So the thrust is given in the principle of equity itself. Any kind of inequity, if at all exists there in the organizations, that will create a lot of problem, lot of threat to the organizational prosperity. So that's the reason why equity should be maintained in terms of the status, facilities, and whatever opportunities that are being given to the workplace itself. Right? So equity in terms of us, if we have understood that, no, compensations are to be based on the principle of equity, where each and every job which are having similar sort of duties, responsibilities, hazards involved, threats involved should be paid equally. So that has to be based on this concept, this directive principle section, Article 33, 38, right? So one thing we need to understand that the Minimum Wages Act, if we do refer to 1948, where it says that the process of fixing up and revising the minimum wages is completely based on these directive principles only. Similarly, Article 39, if you do refer, it declares that the state shall in particular direct its policy towards securing the citizens, men and women equally. They have the right to adequate means of livelihood and equal pay for equal work. You can see based on this only, of course, it was late, but equal remuneration plans, right, have been incorporated in India. Though we do lack in terms of certain acts like EEOs, in equal employment opportunities in other countries, but we do have the subsequent reservation schemes where each and everyone, they are being provided with equal opportunity, and particularly equal remuneration acts do focus in terms of minimizing those wage inequalities based on gender discriminations, based on skill discriminations, or whatever the discriminations it may be. But the objective is to avoid all of those kind of discriminations and to establish this equal pay for equal work kind of thing. We are talking of Article 41, where this state shall, within the limits of its economic capacity and development, make effective provisions for securing the right to work, education, and public assistance, unemployment, old age, sickness, disablement, and other causes of undeserved wants. It's like the focus is given on the establishment of social security and social assistance laws. So we need to talk of this concept of social security divided into two concepts, like social assistance and social insurances. Social assistance is a situation where workers are not being able to contribute for their own social securities, whereas social insurances are a contributory process where workers can contribute along with the employers and the government to protect or safeguard their own unforeseen days of life or old age or maybe health issues or any kind of temporary or permanent unemployment issues, whatever it may be. So the thrust is on the enactment of social security related legislation. So we do have Workmen's Compensation Act, we do have Employees State Insurance Act, we do have Provident Fund Act, we do have pension scheme under Provident Fund Act, and we do have Maternity Benefit Act. All of these enactments are derived from this Article 41 of Directive Principles. And Article 43 says the state shall endeavor to secure all the workers, including agriculture and industrial workers, a minimum living wage the conditions of work, decent standard of life, full enjoyment of leisure, and social and cultural opportunities. This is what we have understood, no, in some of our previous sessions. Like the wages can be divided into the lowest level, that is need-based minimum wage, to the highest level of wage, which is the living wage. And the recommendation of the constitution is that in no way for all the workers, right? For all the workers, the payment should not be less than that of the living wage. If you are paying more than the living wage, it's good, well accepted. But at least you should pay at the living wage rate, right? Which includes all bare essentials of life, which include component for their productivity, for their contribution, for their performances, which include all the frugal comforts of life, which include to satisfy their social obligations to live in a civilized society. So all of these factors are to be taken for deciding the level of wage. So that is how the influence is there from the Constitution of India through the directive principles only, which has made us to enact many such legislations related to this compensation, which do regulate the administration of this compensation and benefit in organizations. So basically, the legal frameworks includes the Minimum Wages Act 1948, the Payment of Wages Act 1936, Payment of Bonus Act 1965, and the Equal Remuneration Act 1976. Right? Welfare legislations, as I was telling you, social security related legislations, right? The Employee State Insurance Act 48, Employees Provident Fund Act 52 1952 itself, right? And we do have Pension Scheme 1992 and Maternity Benefit Act, Workmen's Compensation Act. All of these enactments, whatever we have witnessed till today, is derived from those directive principles of state policies. Okay? So going beyond that, let us now talk of the ways in which these wages and salaries are actually fixed, or the institutions which are responsible for the fixing up and devising the minimum rate of wages in the organizations, right? We're talking of the unilateral pay fixation methods, like one of the ways in which this wages and salaries are fixed only by the employers in the organization. Now, what is the reason for which these employers do enjoy the liberty of fixing up and devising the minimum wages at their end? We do see that most of the Indian workers are unorganized. 92% of the labor forces in India are unorganized. Okay? And unorganized means they don't belong to any kind of associations, right? Or they don't belong to any kind of unions of their own. So ultimately, when it comes to the fixation of wages and salaries, the responsibility goes to the employers, right? So these employers do enjoy the liberty of fixing up and revising the wages at their end. Of course, they cannot violate the rules and regulations imposed by the appropriate government itself. So they cannot pay less than that of the minimum wage as defined by the Minimum Wages Act 1948. But still, when the concept is that the people should be paid with a living wage, why they should be paid at the minimum wage, right? So that is the reason these employers do enjoy the benefit of fixing up and revising the wages unilaterally, right? We are talking of the reason for which workers are paid times less than that of the minimum wage saving. The basic benefits, as has been ensured in different acts, are deprived of, right? They're not getting all of those things, like the basic provisions of health, safety, welfare, working days, working hours. Everywhere there are discriminations. So at one point of time, we said that employers do have the liberty of taking the decision, but mostly they do take the decisions in favor of them. favorable to the employer or to the organization, what makes the life of these workers miserable? And there are discrimination, significant discriminations observed in terms of the wages and benefits which are administered by the organizations, which are defined by the you know, employers unilaterally. So that's the reason why people or these workers in organized sector do have the advantage than that of the unorganized sector, where this employees belonging to the unorganized sector, workers belonging to the unorganized sector, they do have less bargaining power and raise a question about the fairness and equity. But because they don't have that bargaining power, right? So that's the only reason why these workers know they do suffer a lot because they are not organized. They don't belong to any kind of union in the organization, right? So unilateral pay fixation is a process where these employers do have the liberty of the fixing of these wages from time to time without any consultation. But at the same time, when we talk of a bipartite process, a bilateral process, right? We refer to the process of collective bargaining. Collective bargaining is a process of fixing up and revising the minimum rates of wages from time to time with a mutual consultation. So we said that collective bargaining is a process where representative of the workers and the representative of the management, they sit together to finalize the terms and conditions of employment and the aspects of wages and salaries. Wages, its component, salary, its component are a part of the term and condition of employment. So that is the reason why these collective bargaining processes are more successful in fixing up and revising the minimum rates of wages, as it takes both the parties, like employers and the representative of the workers, together to finalize the wages and salaries. The problem is that the union density in India is only about 6%, out of which around 4% are central government or state government or public sector organizations only. So the union activities are confined to few such organizations having larger mass of workers. But what about other organizations? In industrial processes. So there is a like actually in India we do have a huge problem for the unionization. Even if we do have the Trade Union Act 1926 to regulate the trade union activities, but still these trade union activities are not streamlined and not regulated in India. Okay. So whenever we are talking of this wage fixation processes through the process of collective bargaining, as I said, collective bargaining is a process where representative of workers and representative of management, they sit together to finalize the terms and conditions of employment. Wages and salaries are a part of that, right? So it can broadly be divided into three such categories. One is the sectoral bargaining, the second one is industry oriented bargaining or this region wise bargaining agreement. Third one is this decentralized firm or plan table of agreements, right? If we to talk of the first one, sectoral bargaining. Actually, the sectoral bargaining happens at the national level, right? Where the appropriate government is the central government. The central government plays a dominant role, right? So all those central government organizations like banks, courts, steel, port, docks, right, railways, all of these organizations, where there has to be a collective bargaining process. So the appropriate government, central government, will send its nominations, will send its representatives to the bargaining workers, mostly through their unions. So here, like the workers' unions at the national level, what do you call it as federations also, right? Like AITUC, INTUC, BMS, CITU. These are the nationalized unions, right? And these nationalized unions do have the authority to nominate their members for any kind of bargaining process. So sectoral bargaining happens to be there, for different kind of organizations at national level, and most confining to the central government employees only. Right? We come out with industry-wide agreements or these region-wide agreements. Right? These kind of agreements are commonly observed in certain like industry types like cotton, jute, textiles, engineering, tea, right? Where you'll see that the dominant leadership is from the private sectors only. So it's the private sector organizations who do play a significant role in defining the uh, wages and salaries for the workers. Right? So agreements are not binding in respective industries or regions unless they are authorized by the respective employers association. So only these employers associations are you know playing a dominant role in fixing up the wages and salaries for different industries, right? But mostly wages and salaries can be defined at the plant level, lowest level, at the plant level, let's say. Right. So as we said that plant level is the workers' representatives and employees' representatives. They do go for a bargain, right? But mostly there's a disagreement. Unions do have the opinion to carry out this plant level agreements at organizational level agreements, it's company level agreements. That should be applied for all the plants within the same premises, right? So mostly the management of the organizations they don't accept this company-wide bargaining processes, right? So employees sometimes they do come out with this process of registration, recognition, so that they can take part in the decision making process. They can involve themselves in the collective bargaining, in workers' participation in management, right? Where the objective is to ensure that there are proper administration of this compensation things, right? So the bargaining can be done at central level or at state level or at plant level at the most, right? But continuing with that, what should be the actually like when it comes to the process of bargaining says the workers to come out with their proposals, management counters that, management proposes certain things, workers do counter that. So this bargaining takes through the process of proposals, counter proposals, proposals, counter proposals, etc. But when they arrive at a amicable solution, so that is documented and the document is signed by both the parties, right? So once uh, this document is prepared, the bargaining agreement, right, has to be applied for a certain period of time. We have observed, a shift in this bargaining time frame from 1970s to early 2000. Right? Earlier, any kind of bargaining which was made between these workers and the management were applicable for hardly for 2 to 3 years. 1980s, it was made from 4 to 5 years. 1990s, 5 6 years. Now, once an agreement is formed, that is applicable for 5 or 6 years. But the highest goes like when in the year 2000, government went for an agreement with the workers, whereby the agreement was applicable for 9 years. But you need to understand one thing, that the process of fixation and revision of wages are to be done with subsequent time gaps, because we are witnessing a severe inflation in our economy. So commodity price increases, wholesale price increases, all India consumer price index also is, not in a proper growth way, we can say. Right? So here, mostly once an agreement is formed, that is applicable for 3 to 4 years maximum. So on an average, all the organizations, they do go for 3 years of agreement, but sometimes they do also go for 4 years of agreements, right? But the success of or failure of these agreements are completely based on the attitude that both the management and the employers do have for one another, right? And the consideration uh, of the adversarial relationship in most situations. These are the two things that we need to take into consideration with all such seriousness, so that the process of collective bargaining can be implemented properly, right? Collective bargaining can it can resolve many such other things. Beyond this collective bargaining, as we discussed, that there are pay commissions appointed by the appropriate government, right, from time to time, to look into the matter of laborers and come out with certain creative solutions, right, with the basic objective of fixing up and revising the rates of wages. Right? So, a joint consultative machinery. These pay commissions are formed jointly by the appropriate government, and like sometimes the employers representative, some independent representatives are also been taken, who can really do justice to the workers itself. Right? So objective is they need to discuss and finalize all these provisions related to the welfare of the employees, improving the efficiency, the standards of work. All of those are the hidden like objectives for which these pay commissions are appointed. However, certain pay commissions provide a limited extent of this compulsory arbitration, but otherwise arbitration can also be. Arbitration is the appointment of no, a representative by the parties to the dispute, right? So employers and employees, they sit to decide a particular person, neutral to both, to provide his decision related to that, right? And the decision of the arbitrator will be final and binding, right? That is how we to come out with. So what they do is that this arbitration takes this pay and allowances, weekly hours of work, leave of this class or grade of the employees, etc. These are the major issues related to this compensation and benefit administration, which are to be taken by these pay commissions, right? So all the forms of all, like if you refer to the history, right, most of the labor unrests that happen in India are related to this compensation and benefit administration. Right? So, if we really want to have, or if you really want to foster that industrial peace and harmony, so there we need to think of making the or involving these unions for deciding anything. Right? So all the different aspects of the pay structure, your basic wage, DA, HRA, no, city compensatory allowance, travel allowance, tour allowance, whatever it may be, you to talk of. Everything has to be defined, right? And weekly hours of work. Practice Act defined that in no case the employees shall be allowed to work for 48 hours a week, 6 days a week. The seventh day has to be a paid holiday. Okay. That means the maximum working hour for a worker is 8 hours. But depending on the nature of the job itself, what you can understand is the worker is allowed to work the entire shift with a break of minimum 30 minutes between the two, right? So at this stage, these jobs can be assigned to the worker for not more than 5 hours a day. So anyhow, a break of 30 minutes has to be introduced after 5 hours time, right? So here in this case, what you need to understand, the total number of working hours can be extended up to 9 hours, but with due permission from the inspector of factories and boilers, factory inspectors, right? Similarly, in case the worker is requested to carry overtime work, so double the payment of the overtime should be provided to the workers. And in that case, the maximum extended period will be 2.5 hours. Right? So you need to understand one thing, that whatever the case may be, but workers cannot be allowed to work in any factory for more than 10 hours, 30 minutes. Right? Including overtime, all of those things. So how it is defined? Weekly hours, hours of work. Like each and every organization, they do have their own leave rules, right? Based on the central leave rule or based on the respective states' leave rules, right? So how many number of days of casual leave, earned leave, HAPs, half average pays, medical leave, or any other special leave can be granted to the workers, right? That is also a factor to be taken into consideration, right? So as a whole, pay commissions do take all of these factors into consideration for fixing up and revising their payment structure itself. So certain things that we need to know about this pay commissions are like this pay commissions function as a non-statutory body appointed by the central government or appointed by the state government, but this is not a statutory body. So the central government or the respective state governments can appoint these pay commissions from time to time. As if we have now understood, no? Since our independence till now, we have got only 7 pay commissions. So each and every 10 years, there is a pay commission. What are the roles and responsibilities? To study the problems, right? Establishing their own procedures for the collection of data and information. So only a vague study will not help us out in understanding the root cause of the problem. So that is the reason why after this, pilot surveys of carrying out the brief of the research procedures, these pay commissions do define their own procedures for collection of data, right? And they also make recommendations to the government for carrying out certain processes, certain things which enables this, workers to come up with their basic amenities being taken care of, right? So as we discussed, as of now we have got seven such pay commissions being appointed in India as of now. The first pay commission gives thrust on fair relativity, right, among the government employees and outside rates. So there has to be uniformity in the wage rates, right? So government rate should not be different from that of the private organizations, or this private organization should not be distinguished from that of the rural organizations, like remote area organizations. So it has to be based on the fairness and the relativity, right? So that is what. Second pay commission focuses on fair comparison between rates of remuneration and for comparable work could be adopted, right? That means what? This second pay commission focused on the principle of equity, but external, right? Fair comparison between the rates of the remuneration. Actually, there's a saying like we are no more concerned for our own salaries, but we are concerned for the salaries of other people, right? So, is it satisfying the external equity principles, right? And where we do have these benchmarking methods or comparable methods, whether this remuneration or rates of remuneration for this comparable work could be adopted, all of those things, right? So second pay commissions do focus on the fair comparison of these rates of remuneration, right? Third pay commission focuses on equal pay for equal work, right? Which is again based on the principle of equity itself. And that is the reason why concepts such as job evaluations, job analysis, or preparing this job description, job profile, right? All of those things are to be there. Fourth central pay commission, they have focused on fair wages of the employees. Now, what is that fair wage? We have understood that workers' wage can be based on the kind of productivity that the workers do have, right? So what it says, like workers are paid out of their productivity, right? So the concept of fair wage focused on four different aspects of this wage and salary fixation itself, right? First one is that it depends on the productivity of the laborers. Second one is that it is based on the location of the industry in the economy, right? It is based on the kind of resources available, the labor trend itself, right? Demand and supply of laborers, right? And so that's the reason why it was advised that workers should be paid as per their contribution they are making towards the organization, right? The fifth pay commission focuses on linking the pay revision with the work organization and manpower planning itself. So here, the fifth pay commission, they have gone, they have stretched a bit beyond their normal day-to-day operations to link these compensation strategies with the organizational goals, right? So organizations goals are to be achieved, and the people must be or workers must be ready to accomplish the same objective. Six central pay commissions, the job fitment factor was adopted, right? Job fitment processes, the how these jobs can be matched with the content of the job. Okay? Sometimes job title says something, you do have something else to offer, right? That means what? Let's see, nowadays, no, giving or assigning designations are no more a concern from the private players, but as such, many such organizations will find out that their duties and responsibilities are completely different from that of what is being assigned to them. Right? So that's the only reason for which you'll see that this fitment process are not being taken into consideration, right? And we have witnessed recently the seventh Central Pay Commission. Seven Central Pay Commissions uh, recommended the payment system as per a salary matrix, wage matrix itself. Okay? We have discussed that in some of our previous classes also, right? And we have got the fourth such institutional mechanism for the fixation of these wages and salaries are these wage boards. Okay? And these wage boards are the voluntary negotiating bodies set up by the discussion between these organized employers and workers to regulate the wage, working hours, relative conditions of employment by collective. So wage boards are voluntary organizations appointed by workers representatives, it's mostly unions, and then we do talk of the employers, right, representatives. Now mostly these wage boards are set up by certain law or with certain legal authorities itself. So central government or the appropriate government we can say do have an impact on these wage boards, even if it is a bipartite board, right? They do regulate the activities of this wage boards itself, right? So the basic objective of these wage boards are to regulate these wages, working conditions, right, working hours, uh, to fix up the minimum level of wage and other standards of employment, right, which can then legally be enforced. Right? Now, what we need to understand is that these wage boards take different aspects together to fix up and revise the minimum level of wage from time to time, like the industry's position in the economy, right? Mostly the contribution of the industry to the economy, to its GDP, right, is what that is being valued. So of course, we do have Ministry of HRD, Ministry of Finance to look after all of those things. But to what extent that industry contributes for the growth and development of the nation's economy is what that is being focused, right? Requirement of social justice, we have already discussed that. Social justice. Cost of living index, right, is the consistent increase in the price ranges of the commodities, right? We'll talk of that. Capacity of the industry to pay. Of course, any such organization do not have the responsibility of making any kind of payment for or till the organizations to make a huge profit, but depends on the financial strength of that particular industry. If it is a labor intensive industry, normally the payment are less. If it is a capital intensive industry, the payment are more. Existing wage differentials, we have understood that these wage differentials are there because of the type of industry, because of the professions, because of the hazards involved, because of the risks involved, because of the nature and duties of this jobs itself, right? So, what are the existing differentials exist over there that should be taken into consideration, right? Productivity of the workers, of course, the wages and salaries are completely based on the productivity of the workers. Consumers' interests are also a factor that this wage board should take into consideration because the ultimate, you know, uh, production shall be consumed by the consumers only. No? So all of those things are there under this wage codes. And in India, we do have two different types of wage codes. One is a statutory wage code. The other one is a tripartite wage code. Statutory wage codes are appointed as per any statute, as per any law of the state or the central government. It is appointed as per any act, right? And the tripartite wage boards are formed as per the uh, planning commission's 5-year plans, right? Recommendation of this planning commission's 5-year plans. These tripartite wage boards are appointed. Tripartite wage boards do have representatives of the workers, the employers, and the government, right? But normally, whenever we to talk of these wage boards, we can think of these wage boards as consisting of equal number of representatives from the employers and the workers, and that the wage board should be headed by a chairperson, which is normally an independent person, right? Sometimes, with the permission of the chairperson, right, an economist or maybe the consumer representative, right, both are to be independent, right, and they are nominated to look after the board's activities. Total number of members can be maximum up to 7 or 9, right? And the total number of wage boards in India actually was existing. If you do refer to 1970s, there are around 19 wage boards. As of now, there is only one wage board existing, right? So this basic responsibility of the wage boards are to fix and revise these various components of the wages itself. But with the emergence of certain other concepts, like the functioning of these wage boards, functioning of the wage boards have been uh, or have lost its significance at the present day. Okay. So beyond that, we do have one more process to fix and revise the wages. If at all there are any such disputes or grievances related to wages and salaries, then the grievance or dispute has to be referred to the court for adjudication. Right? So there, here you can see the process is quite cumbersome, but when I refer to grievances, I refer that grievance is any kind of feeling of injustice, right? Dissatisfaction, discontent, which may be expressed, may not be expressed, right? But is related to the industrial activities are called as grievances. Grievances could be anything, but whenever there is a grievance, you need to understand that these grievances are to be settled, at the primary stance. Reason being, if these grievances are not being settled at the primary level, then these grievances will convert themselves to a dispute. It can be a dispute there, right? Means grievances do happen individually. If not listened, not taken care of, then those individual grievances becomes a group's grievances. Union will come over here then it will take a step of a dispute, right? So, how to resolve that? Maybe in the 36th session of the ILC, certain recommendations were there. Model grievance procedure. So, each and every organization do have their own grievance settlement procedures, right? What it says that there has to be appointed a grievance settlement officer, right? Grievance officer whose duty is to look into the individual grievances. So, if at all an employee has got some kind of grievances towards the job, towards the organization, towards other processes, the aggrieved employee should communicate the same to the next level of hierarchy. Look, maybe the head of the departments, right? Any kind of thing. This is a verbal communication. The supervisor or the head of the department is bound to reply back within 24 hours. If not, then the worker can give a writing to the next level or maybe to the head of the departments to provide a solution, right? And the head of the department must provide the solution within 48 hours time to the India. If at all not settled, right? If the decision of the head of the department is not accepted by the worker, then the worker can go further to make an application to the grievance committee, right? And grievance committee has to reply back within 72 hours, 3 days. Now, all of these steps have been taken to ensure that the grievances are handled at the individual level. But even after that, if the grievance is not settled, then the grievance will be referred to the court for the process of adjudication. What it says is a process of referring the case to the court. Now, unlike the civil court and criminal court, to deal with any such labor-related issues, right, we do have three parallel courts. One is labor court, industrial tribunal, and national tribunal. Right? Schedule 2 of the Factories Act mentions that what are the cases where it can be referred to the labor court, which are the cases which can be referred to the industrial tribunal, and any such matter of importance which happens to be there at the national level, right, are to be referred to the national tribunal, right? And this adjudication process is a process of finalizing any kind of disputes, and the award is final and binding on the parties. Of course, you have the liberty to go for some higher cases like high courts or Supreme Courts, but here it is binding. Right? So all the matter pertaining to this compensation and reward management, benefit administration, any other issues are referred to these labor courts or industrial tribunals or national tribunals only for the settlement, right? So that is how we think of like settling any kind of grievances or disputes through the courts itself. Most of the disputes are no, most of the disputes are there because of no such reasons, right? With proper agreement between this management and the workers can avoid many such different kinds of disputes existing over there. So even the government policies, the public policies, allow the settlement of any such issue related to this compensation and benefit administration before the case is referred to the labor court or industrial tribunal or national. So that is how we need to understand that all of these cases are to be referred to respective courts. Right? So, friends, these are the institutions or institutional frameworks which helps us out in fixing up and revising these compensation policies. Right? So either it can be done unilaterally by the employer himself without consulting the workers, right? So employers do have the advantage, but workers don't like that process. It can be bilateral through the process of collective bargaining, where the representative of the workers and the representative of the management sit together to finalize the terms and conditions of employment, right? Third, we have understood that the pay commissions are there, and pay commissions as of now, from first to say 10th pay commissions, right? Some or other kind of changes are witnessed. The situations which were there during the appointment of the first pay commission was not there for the 7th pay commission. Right? Similarly, in due course of time, the wage boards have lost their relevance. As compared to 19 wage boards in 1970s to only one wage board, working journalist wage board is existing. All other wage boards have lost their relevance. Right? And we can also think of these decisions by the labor court, industrial tribunals or national tribunals. Right? So these are the institutional framework, various institutional frameworks that we need to take into consideration. But one thing we need to understand that these wages and salaries are to be taken in both the ways, right? Both the variants. At one point of time, we do take the legalities, legal considerations for the purpose of these wages and salaries. But at the other side, we need to think of the humanitarian aspects of the wages and salaries also. Humanitarian aspects in a sense that the process of humanization and humanism should not be underestimated in the course. Right? So let us wind it over here for today, and we have come to the end of this block 3, where we have discussed this unit 7, 8, and 9, 10, and we are left out with this block 4, right? Section no, unit 11, 12, and 13. We'll discuss that later on, right? But basically, we are going to discuss the various methods of making the payments, and what are the methods in which this compensation benefits to be administered, incentives to be administered, bonuses to be administered. So all of these are the methods that we would like to see and discuss in detail in block 4. So let us end it over here, and thank you very much for attending this session.